when I got the email from the defense lawyer that they were going to file for punitive damages, it almost sent me over the edge. I had already dealt with the preparation. I had already dealt with the deposition that was terrible and 9 hours long. And I thought I was dealing with things off and on okay. And then I got this email the night I was going to take the kids to an event at church. And I dropped my phone onto the bed and just started sobbing.
It's Season 3, Episode 7 of the Doctors and Litigation, the L Word podcast. I'm your host, Gita Pensa. Today we're going to talk about the increasing weaponization of punitive damages in medical malpractice litigation. The voice you just heard is that of one of my physician coaching clients. I'm going to call her Dr. S. And we're going to get back to her in just 1 second. But before we start talking about some pretty heavy stuff, I want to shift gears and just take a moment to celebrate the 7th anniversary of this podcast. I released the first episode in April 2019, a year after my second trial. And if you've heard the story of the podcast in Season 1, you know that at first it was just this little side passion project of mine that, maybe my residents at Brown were going to listen to it. Who knew? So the first few years were rather sporadic. And then once I realized folks were really waiting on it, learning from it, depending on it, then I got a little more organized. And of course, now we are in Season 3. So I have to thank you all for sharing and listening. And last year, shockingly to me, Doctors and Litigation was in the top 100 Apple Health and Fitness podcasts, which I think is crazy because we don't have a general population listenership. It gets in a category with a lot of general health podcasts that lay people listen to. But anyway, I think I've been bumped out again, but who's keeping track, right? In those lucky 7 years, a lot has happened, and the need for us to all come together around this topic, I don't think has ever been greater, which brings me back to today's topic and Dr. S. Dr. S was a physician involved in a complex case in which her care was excellent, and yet, as does happen sometimes in medicine, there was a very unfortunate outcome in an infant. It was truly heartbreaking for everyone involved, including Dr. S, who was then, somewhat predictably, sued. And then the demand for a settlement was initially many, 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 many millions of dollars. Now, of course, Dr. S's policy had a limit of $1 million, and her care was good, and her insurer did not feel that they should settle for millions and millions and millions of dollars in a scenario in which the care was good, in which the doctor did everything that she could reasonably have been expected to do. The insurer and Dr. S were geared up for trial. The doctor was preparing herself, but was highly stressed, as makes sense. Now, I invite you to think like a plaintiff's attorney, which we talked about in the Educated Defendant episode, and we'll talk about again soon. But recall that a plaintiff's attorney takes generally half or more of any settlement or verdict. And what does a plaintiff's attorney do when they want a massive settlement, but they probably know that the care was pretty good? They would prefer not to take it to trial because then they would potentially get nothing if a jury understood what reasonable care is, which is, of course, a gamble for both sides. A settlement would be a bird in hand, but how do you make that bird as fat as possible when the insurance company wants to defend what they see as good care? How do they possibly turn the screws so that the insurer might be willing to jack up that dollar amount? And if the insurer or the defendant aren't playing ball the way they want, well, where else could they apply pressure?
I couldn't believe that this patient that I had a good relationship with, that I had developed over the years, and I felt even after getting sued that this wasn't necessarily her personally, but because she needed the money to help take care of her child. Now it felt really personal, and it felt like, how could she allow her lawyers to come after me in a way that made it sound like I was trying to hurt her?
Plaintiffs' attorneys have taken a tool that was meant to be applied rarely and in egregious cases and have started to make the application routine in states that allow it.
punitive damages are just a tool that plaintiff lawyers think is, oh, this is a good way to get a little bit more money. And in actuality, it can be devastating.
Now, my client is in the Midwest, but in places like New Mexico, until recently, over 90% of cases included claims for punitive damages. Not because every case involved reckless care, but because punitive damages raise the stakes in a very, very specific way. They are not covered by insurance. They are meant to punish the doctor by decimating them financially. So that means that doctors aren't just defending their care, they're defending their life savings, their personal assets, their livelihoods, their future. Even if the defense attorney tells their client, don't worry about it, this won't stick, they do this all the time, it's not going to hammer out, you'll see, it doesn't matter. When that kind of threat shows up in a case, it does what it's designed to do. It creates fear and panic in the defendant, who will do just about anything to avoid the chance of a jury awarding punitive damages in the millions, which will not be paid by insurance, and it pushes doctors to the brink and cases towards settlement, even when the medicine was completely sound. There's also the added shame. You believe this was supposed to be for egregious cases, for the truly bad actors, and now these allegations are geared at you and in the public record? Your colleagues, your family, your friends might find this out. Do they believe, as most people do, that there must be some basis for the punitive damages? How shameful. How debilitating. The terror is the point. The psychological warfare is the point. They're not expecting to get the punitive damages awarded. They are gunning for the implosion of the physician and the increased pressure for the insurer to agree to a larger settlement. The physician begins to strategize around ways to force a settlement to avoid their personal risk if they go to trial, and they are also in no psychological state to prepare adequately for trial.
I was dealing with litigation stress syndrome, which I feel like is a combination of PTSD and moral injury, and that punitive damage letter sent me in a spiral in a way that I felt like I couldn't function anymore. And I used the employee assistance program, which wasn't specific enough. I went to my personal counselor that I've used for other reasons, and it just wasn't specific enough to really feel like someone heard me. And it really wasn't until I started getting coaching with you that I started feeling like I was coming out of it, where I could have someone who really understood what it felt like to have someone accuse you of being a terrible person and a horrible doctor and not knowing at all what you're doing. And once I started getting the coaching, I felt like I had someone in my corner that knew exactly how it felt, even more so than my lawyer, who did know a lot about, actually everything about law that I didn't know, but really didn't know how it felt to be sued and to have that threatened your livelihood, everything that you hold dear as far as your career goes.
The bottom line is we need help. We can't do this alone. We need better systems of support and more insistent and strategic advocacy. We all need to understand how the game is changing and what it's doing to us and to our friends and our colleagues and our patients' access to care. And we need to learn how to stand up and say, this is not right, and it has to stop. And to that end, I have a guest today to talk to us about punitive damages, the care crisis in New Mexico, and how advocacy is helping to turn the tide. I'm so grateful to have attorney Jessica Marshall to talk about it all with us. Jessica is a partner in the Albuquerque office of Meyer LLP, where she focuses on medical malpractice defense, employment law, and personal injury litigation. She represents physicians, healthcare professionals, and facilities through all stages of litigation, and was recognized as a Best Lawyers One to Watch and a Southwest Super Lawyers Rising Star. Jessica's here to educate us about these issues and give us frameworks to think about what we can all be doing in our own states to advocate. Jessica Marshall, thank you so much for coming to the podcast to talk about the state of things in New Mexico and the weaponization of punitive damages.
Thank you so much for having me. I appreciate being here. I have been representing doctors, nurses, clinics, and hospital systems for a while now, and the medical malpractice environment in New Mexico has changed pretty dramatically over the last couple of years.
First, tell us a little bit about yourself and where you practice and how it is that you got into the defense side of things. And then let's talk about what's changed in New Mexico.
Absolutely. So I'm Jessica Marshall. I'm a partner with Meyer LLP in our medical malpractice division. I'm in New Mexico. I live in Albuquerque, and I've been doing medical malpractice for pretty much my entire career. It's something I think I actually fell into on accident. We had two lawyers by the name of Jessica at one of my old firms. One of them was a lawyer and a PA. And I think I accidentally got the referral from the partner and it just stuck.
Oh, wow. Okay. All right. Well, how fortuitous for us because you have hung in there. Defense in New Mexico has been pretty rough recently.
It has been. There's some silver lining and some good things that are just starting this year after a lot of work, but it has been a really difficult environment for our doctors for many years now.
So, for listeners who may not be familiar, or who don't live in New Mexico, or who haven't been following all the things I've been reposting on social media, what is or has been unique about the malpractice climate in New Mexico? Like, how has it changed in the last few years? And what is it that has made it such a spotlight for those of us who are interested in the impact of the medical malpractice climate and access to care?
So I'll give a little bit of background about how medical malpractice cases work in New Mexico. We really have two types of malpractice cases. One is cases that fall under the New Mexico Medical Malpractice Act, or the MMA, and those that don't, which we call common law negligence claims. The MMA was enacted back in 1976 because there was an ongoing, really significant problem with a lack of availability of insurance for our doctors. So New Mexico was losing its providers. We enacted the MMA in order to avoid losing our last neurosurgeon in the state, which would mean we would have no level 1 or level 2 trauma centers.
And was this in response to the malpractice climate at that time?
It was at that time. So the MMA intended to provide caps on what we call non-economic damages for those who chose to participate in the patient compensation fund and be what's called a qualified healthcare provider under the act. It's a term of art under the statute.
There are many people listening who don't have any system like that in their state. Can you just talk very briefly about how did that work? What happened? There was an adverse event, and what would happen with the MMA?
So if you participate in the patient compensation fund, which requires that you have a certain type of insurance at a certain level and that you pay premiums or into the patient compensation fund in order to qualify. Right. And if you do, then you get to go before a panel, before the lawsuit's brought in, to have a couple doctors and lawyers hear the case and determine if they think that there's medical negligence or not, and if the patient was harmed. Those results happen. They do not carry any weight in the actual litigation, but it does provide a cap on the non-economic damages. Now, those caps have changed because there was an amendment in 2021 during the height of COVID that increased all of those caps pretty significantly and created new categories of caps for different types of providers or hospital systems. As you can imagine, the hospital system caps are significantly higher than what we see for our doctors. And that went through and actually caused a bit of an insurance crisis.
Okay, so let's start there. Let's talk about what's been happening in the last 5 years.
So that went into effect in 2021. Very quickly after that, the session actually had to come back and do an emergency amendment, the last amendment, because independent outpatient clinics weren't able to get any insurance.
They weren't able to get any insurance because the insurance carriers said New Mexico is way too risky. The caps are through the roof. It's a highly litigious environment. We're going to get our butts kicked and we can't insure you there.
Absolutely. That was what happened. Since the caps have gone up, premiums have gone up, and insurers have left the state, actually, because the environment is such to where for every dollar they put in to premiums as the insured doctor or hospital, the insurance companies are paying out $1.83 in loss. It's an environment that's just not economically feasible anymore.
And tell me about how that 2021 amendment went through and what the climate was and what drove that.
So that was a lobbying effort by the New Mexico Trial Lawyers Association, also known as the Plaintiffs' Bar in New Mexico, those who represent patients that have been injured. And it was done during the height of COVID. And we, of course, still had social distancing and things like that in effect. So it was difficult for doctors to come in, lobby on their own behalf and say, hey, this is going to be a bad decision. This is going to have really significant impacts on us. Please don't do this. And so it kind of slid in that session.
And New Mexico also has just a very high rate of litigation in general, I understand.
They do. For every 14,000 New Mexicans, there is one lawsuit filed. That's more than twice the national average, where you're seeing one lawsuit for every 34,000 Americans. So that's a significant increase.
So like more than twice the national average rate of litigation, I guess is the way to say it.
Absolutely. And it's not like New Mexico doctors are doing anything any different than other doctors in other areas of the state. Rather, our policies have created an environment where it's incentivizes lawsuits to be filed here.
So New Mexico already at its baseline, at least the way I imagine it, had a lot of rural and perhaps underserved communities to begin with. How does the malpractice environment, so now we have a highly litigious state that, incentivizes plaintiffs' lawyers to bring cases, the caps have all been either eliminated or raised, and it's hard for providers to get insurance. What has been happening with access to care?
It's been a really complex issue. So when you have a majority of your state that's rural, like New Mexico is, there are medical deserts where they can't get quickly or easily to a hospital or a doctor. Mm-hmm. So we have small hospital systems and clinics around the state that have shut their doors, that can no longer afford to get insurance. And when you have a system that's working on small margins, then margins in their budgets, with Medicare and Medicaid reimbursement being what it is, mm-hmm. it means that these increases in premiums can be devastating. It affects their ability to keep services open, and it affects their ability to recruit providers. For instance, Roosevelt General Hospital in New Mexico had an almost triple increase in their insurance premiums over a 2-year time frame.
Wow.
It was $330,000 in 2021 for insurance, and then in 2023 it was $820,000.
Oh my goodness. And also you have individual providers who are trying to get insurance on their own if they're independent, if they're not employed by a hospital, they may be trying to get private insurance. I've heard obstetricians talk about how their premiums were well in the 6 figures a year, and they simply couldn't afford to stay in New Mexico. And then on the other side of that, you have patients now who have to drive 6-8 hours to get obstetrics care.
Absolutely. It's a really difficult situation for our providers that choose to have small independent practices, because if they can't afford to keep that insurance, they either have to close their clinic, go practice in a larger system, or they have to move. And when that system closes, that entire community loses access to care.
Yeah.
And so if they can't get to a primary, an obstetrician, a specialist, that's going to be a compounding problem.
I was reading an op-ed in the Albuquerque local newspaper. I think it was an OBGYN who had written an article about how incentivized they were to leave the state, and how she would get advertising from other states being like, leaving New Mexico is a strategic decision. You should, think about how much better it is, in this state. I think it sounded like it broke her heart, but you couldn't not think about that.
You can't not think about it. And I saw that op-ed too. And we have a lot of doctors in New Mexico that were born and raised here, have their families here, want to be here. Yeah. And when they can't continue to work in their own community, it is heartbreaking, because they're going to have to uproot not just their practice, but their whole family's lives and shift somewhere new. And that's a devastating thing to know, that you might be closing the doors to the only obstetrician within 100 miles of your community.
So this is very much a patient care issue as much as it is a physician, both financial solvency and personal issue. Like, this is where it all interacts. And I'm not really sure that this is a patient safety issue as much as it's been branded as.
It really hasn't been addressed as much. We see arguments back of, oh, insurance pays for this and it's covered and this isn't a big deal. None of that's actually true.
Yeah.
And when you have a story like, there was a mother-to-be who lost her only labor and delivery clinic in her area and had to travel over an hour each way in order to receive prenatal care. So this soon-to-be mother was coming back from a prenatal visit, and her car was knocked over by a strong gust of wind, as we have in some of the rural areas in New Mexico. We get big windstorms.
Wow.
And it flipped her car. And unfortunately, she and her unborn child lost their life because she had to travel for care.
Wow. So multifactorial. And let's get back to something that you said about a lot of people are like, oh, the insurance company will pay. The insurance company will pay. This is not really about the doctors, which is this whole series is about how that's not the case. But let us talk now. And I really want to spend some time on this. Let us talk now about a very particular thing that happened in New Mexico with the weaponization of punitive damages in these cases. My understanding is that punitive damages are alleged very, very early in cases in New Mexico, often before discovery is complete. Like, how common was that, or has that been in New Mexico, and what does it change legally, strategically for the doctor?
So it's incredibly common. I think in the entirety of my practice, I only remember 2 cases where punitive damages were not alleged.
Come on.
Yeah. Yeah. It's early, it's often. And then the discovery, which is where you have to answer questions, produce documents, sit for a deposition, get to include discovery into those claims. So it opens up doctors' bank statements, their spending habits, and their personal assets all become a part of discovery. And not only is that incredibly uncomfortable and inappropriate, but it's terrifying because insurance does not cover punitive damages awards. Those are the personal liability of those physicians. And so that's a terrifying situation for them to be in, to know that they're facing potential financial ruin.
So let's back up a second, because this greatly upsets me. It's probably going to be upsetting to the people who hear it. When a case has punitive damages attached, let us think for a second about what the implications are for the defendant and how it can affect a case. Like, what are punitive damages supposed to be for?
So punitive damages are intended to be a punishment for really what's egregious conduct, not just a mistake. There's generally 2 types of damages that are pled in cases. One is compensatory, which is we're trying to make you whole because you've been harmed. When we're trying to do that, we say, okay, what are your medical bills? Did you lose any wages? Did you have pain and suffering for the non-economic damages? That's to try to make you whole from a financial standpoint. Punitive damages are you've done something so above and beyond wrong that we must punish you. And the way that we're going to punish you is by generally a multiplier of whatever the compensatory damages are. And in New Mexico specifically, that has been a real problem because other states either don't allow punitive damages claims, require a higher standard, a higher burden of proof to prove to the jury that punitive damages are warranted.
Mm-hmm.
Or they don't allow you to bring the claim until later after you've established through your discovery process that there's really a basis for bringing punitive damages. Prior to this year, New Mexico didn't require any of that.
What I'd heard is that with some huge percentage, like 90% of cases having punitive damages attached, and with this climate where litigation was highly common, and just the general difficulty of practicing in an environment that was getting increasingly decimated as more and more providers were choosing to leave or could not get insurance, this turned into like just a real perfect storm.
It did. You're facing an environment where costs are going up to defend not only punitive damages claims, right? Because when we defend those, we're talking about people's personal assets. This is a big fight. It's an important fight. But also the numerous other claims that get brought in with like the kitchen sink approach, where let me bring a claim for everything I can think of and see what sticks at trial. But that drives up the defense costs. We have to hire more expert witnesses and they're not cheap.
Mm-hmm.
And that all comes through insurance too. So even if you win the case at the end of the day, premiums have gone up.
Yeah.
When a doctor is facing the risk of, should I settle this case and have a national practitioner's data bank report, which may affect my ability to continue to practice, or should I fight it and go to a jury of 12 strangers and see if they believe me that the care was reasonable, but I might get a punitive damages award because New Mexico's standard used to be much lower, and it might ruin my financials for myself and my family. That's a big deal. And so when you're looking at that, it's going to drive most providers to say, my tolerance for that risk is not high and I want to settle and get me out of this.
Yeah. I mean, that makes sense. That makes sense. When you're saying that we're like exposing all of your assets, we're going to take whatever we can get. It doesn't matter whether or not, I mean, as we've said many times on this podcast, in the majority of lawsuits altogether, there was no negligence at all. And if they're allowed to in the very beginning, before there's even been discovery complete, say, oh, this person deserves to be punished. Their care was so egregious that they deserve to be punished. And we're coming after them for whatever millions of dollars. And then that person realizes, like, this doesn't feel like a fair fight at all. It doesn't feel like it's about my medical care whatsoever. And I don't know that it would be worth the risk. I would think twice before I practiced in New Mexico, to tell you the truth. There are two things that I'm really concerned about, because it's not only in New Mexico where we're seeing the punitive damages. I have had many, many clients so far who have had to contend with this in other states. I see this as something that, as we know, the plaintiffs bar, they talk to one another. And somehow, somewhere, someone thought this was a good idea to use this as a way to turn the screws on the doctor in this way. I made a comment about it once on social media, and I got ratioed by a whole bunch of plaintiffs' attorneys who were like, well, what can we do if the insurance company won't pay out and they won't offer a reasonable settlement? And so we don't have any choice except to allege punitive damages and get the doctor to, make the insurance company give us something reasonable. What do you have to say to that?
That assumes that settlement's always appropriate, right? It's assuming that there was negligence and that settlement's appropriate in every instance, and it's not. When you're looking at care, doctors are making decisions, difficult decisions, usually in a time-limited and complicated situation. And now we hire experts to then sit there and Monday morning quarterback who have significantly more time to say, would I have done this differently? Was that right? That's never going to be the standard, really. But that's what we're facing in these cases. And assuming that you have to threaten a doctor to pressure them into settling a case assumes that your case was meritorious to begin with. There are times when a case is legitimate. A patient has been harmed and they deserve compensation. We've seen those cases. We know they exist. But there's just as many, if not more, cases where that's not the case. And usually it comes from people not understanding what happened. It's a poor outcome. It's tragic. It's heartbreaking. And then we end up with this lawsuit saying, well, we need to ensure they get money. And it's being further pushed by a plaintiff's lawyer who gets to take 40% or more of whatever they get.
It's interesting because I'm interested in what you think about this, but it makes sense to me that when a jury is presented with a case, let's say you do decide to go to trial, or at least you're thinking about this before you go in. When a jury is told that there are punitive damages in this case, we think the case was so egregious that this doctor needs to be punished. Where do they anchor in terms of thinking about reasonableness of care? Is it really hard for a jury to come back from that and be like, oh, no, we think this is absolutely reasonable care?
It can be. It can absolutely anchor a jury. It can absolutely go ahead and frame a system of, we're not looking anymore at whether this was negligence. We're looking at whether it was egregious or not. And that can be really harmful at trial. But despite that, we are seeing cases where even though they're alleging punitive damages and they're spinning a story of, essentially doctors not caring and hospitals not caring, doctors are still winning trials. We're still seeing defense verdicts. And when there are verdicts, we are still seeing some where they're reasonable in damages. But when you anchor with punitive damages claims and you see these news stories about hundreds of millions of dollars and verdicts, it skews the public perception of what's happening and what's reasonable. When you have that and people have this sitting in their memory and their lived experience of seeing $100 million, $500 million, then it takes some of the shock and awe of some of these claims away, and people aren't thinking about them as rationally anymore.
What have you seen? I mean, I certainly reckon, and the clinicians that I work with, that punitive damages, it just raises the stakes so much further in terms of the stress level and the worry and the feeling of betrayal of like, I went to work and I did my best that day, and adverse events are unfortunately inherent to the practice of medicine. And especially these people who are good doctors who, this whole series has been about litigation stress and what happens and how it's not what we think when we come into it. But then this, as something that hasn't been, common knowledge for everybody, like, oh, it's pretty standard to have punitive damages. And I've heard attorneys say that about their clients, like they need to not worry about that. There's no way that's going to go through. They are going to worry about it. What have you seen? Like when you see the stress this takes out on your clients, have you sort of borne witness to what this does to them?
I have. It's kind of heartbreaking in some instances. I've had a client where I was really, really concerned about their mental health and their well-being, what was happening. And that was an alarming situation to be in. But they've all experienced stress. If doctors want to defend the care that they provided, but know that the volatility of 12 strangers deciding whether or not you made a mistake. But did you go out and do something recklessly, intentionally to harm this patient? That sits on them. Doctors didn't go to school and finish their degree and go to residency and take on so much debt to harm a patient or not care about a patient and what happens to them.
Yeah.
These are people who set aside their weekends and their nights to work and to take care of our families, and then are told not only that you made a mistake, but that you're a bad doctor. So they don't want to keep practicing. They call me in the middle of the night and on weekends. I get texts all day long from people who are stressed out entirely about what's going to happen with their case, calling me on their vacations when they're not spending time with their family because they're thinking about the lawsuit, because it sits in the back of the head all the time. And it not only impacts their mental well-being for that case, it's starting to impact the medical community as a whole, because we start seeing more defensive medicine practices, and that's not helpful to anyone else either.
Yeah, I mean, it's terrifying. I think it's terrifying. I understand that the people that I work with, people who are enduring this now, there are probably people listening who have punitive damages attached to their case, and they probably have the experience of their lawyer saying, like, don't worry, it's not going to go anywhere. Eventually, we're going to get rid of that, et cetera, et cetera. We can't let go of that. I mean, it's just absolutely terrifying, and it completely negates, the whole idea of your insurance. Like, what's your insurance for? If they can come back and say, like, well, and now we're going to add this on, and they do it routinely without any evidence of egregious behavior, that this is just a routine tactic in order to basically turn the screws tighter and tighter and tighter until the physician breaks. This is essentially psychological warfare.
It is absolutely psychological warfare. And I think on the defense side, for a couple of years, we were a bit numb to it because we're so used to seeing it. And this is my day in, day out, my work, right?
Mm.
I think we always have to come back and remember that for the doctors, this is the extreme. This is the nightmare. I don't meet doctors generally unless I'm getting care or they're being sued.
Mhm.
They don't want to meet me. For the defense bar, we've had to come back and remind ourselves that these doctors are terrified and they're relying on us to help guide them through this process and to explain to them what punitive damages are, what that could mean for their career, for their future. It's a sad, awful thing to go through, but we have to make sure, and I think it's probably more terrifying for them when we sit down and go over this in detail, but we have to make sure they understand, which could just up that stress level. And now I think that there's a much bigger groundswell happening of, nationwide, we have a doctor shortage, but New Mexico's is pretty severe. We have 32 counties out of 33 that have a healthcare provider shortage.
Mhm.
We have punitive damages alleged in almost every case. And it's driving up settlements, which is National Practitioner Data Bank reports for our doctors who then want to leave the state and have to figure out, how do I navigate this with a new hospital, new licensing body? And so we're starting to push back. There's more of a fight, and we're starting to see some change. And we've had change in Santa Fe with the last legislative session, and we got HB 99 passed, which is going to make a big difference. But there's still a lot of work to be done.
Mhm.
And I think the doctors need to know that, there's a shift happening, I think, across the board right now to try and rebalance these scales.
Tell us a little bit more about what was in HB 99.
So House Bill 99 was brought this session as an effort to try to place a cap on punitive damages, which is a huge win, but also to kind of rebalance how punitive damages are decided by a jury. And so now we have, generally speaking, in New Mexico, when you prove negligence, you have to meet a preponderance of the evidence standard, meaning 51% more likely than not that fact is true. That was also the case for punitive damages claims in New Mexico.
Okay. Wow.
Yeah, not great. That was raised this year. So now we're looking at clear and convincing evidence to prove punitive damages, which is the standard it should be, right?
Mhm.
If we're going to punish someone and say you did something more than just make a mistake, you need to have to prove that.
Now, how about anything to mitigate this wanton application of punitive damages in the first place?
Now they cannot bring punitive damages with the initial complaint. So when they file their lawsuit, punitive damages are not supposed to be in that complaint. Now we've heard some plaintiffs' lawyers say that they're going to disregard that rule. That'll be a fight that comes when it comes. But now you have to go through a significant amount of discovery in order to substantiate amending your complaint to bring a punitive damages claim. Now, to amend in New Mexico is generally pretty easy for a party to amend a complaint. And understandably, it's going to be pretty easy for them to amend here as well. But it gives them the opportunity to say, hey, you've had your discovery. There's no evidence here that shows that I did anything maliciously, wantonly, recklessly, intentionally, that at worst, this is an allegation that a mistake was made. That's a big difference for how we can defend the claims going forward to try and rein in costs there.
And with that, hopefully you can start to protect your workforce because let's be honest, if that was the climate and I had another choice, I wouldn't practice there.
Absolutely. And when you have a nationwide shortage of doctors, they have plenty of choice on where they want to live and practice. And to bring them here, we have to be competitive. Now we're going to have caps on punitive damages. So punitive damages for most defendants will be capped at just 1 times the compensatory damages cap, which is a staggered amount right now. Large hospital systems will see a cap of 2.5 times that amount, which is still a lot of money. We're talking 15 or more $1 million of punitive damages. So it's still high, still very high.
Fair. Like now I'm like, is this a hollow victory? I'm not really, I don't know how I feel about this.
It's still very high, but it's something. It's something to know. I now know what the risk is because when you're seeing verdicts in New Mexico, like $412 million.
Yes.
Now you can sit back and say, okay, even if everything worst case scenario happens, I know what to expect. And I think that alleviates some of the anxiety for providers to understand what could happen and that it's not just unlimited amount.
I think that it's also important for everybody to understand that in many state legislatures, there are quite a number of plaintiffs' attorneys who populate that legislature. And we in medicine have historically just kind of, we're too busy practicing medicine over here to get involved. And I had a whole episode about advocacy. I think in New Mexico, there is, you have your share of plaintiffs' attorneys in the legislature. Some of them who are actively practicing plaintiffs' attorneys while they're actually making laws that benefit themselves. And so someone ought to take a look at that. But I think that what New Mexico really shines a spotlight on is sort of end stage greed, I feel like, from that side. And then what happens to care? Like it will collapse. This is not just about doctors. This is about patients. And I have just a huge bee in my bonnet about this punitive damages thing. It's just this wanton application as a routine tool. But the price that it extracts from the individual doctor, it's like it feels like bear, like you have no protection whatsoever. What was the point of being insured when this is what happens routinely? It just boggles the mind. And it's not just New Mexico. This is happening all over the country. And so I really want to make a big issue about this because we need help. Like we need people to really sort of look at what this does to us as human beings and whether or not this is right. And it's not right.
It's probably not the best comparison, but when you're looking at a lawsuit over a car accident, right? You have insurance that covers that too.
Mm-hmm.
And when someone just makes a mistake and rear ends someone, that's a mistake. Compensatory damages make the plaintiff whole, fix what you caused by making a mistake. Punitive damages are more along the lines of that person was out driving drunk and hit someone. That's something that requires punishment, right? And doctors, by and large, are not a group that necessarily needs to be punished. And I think the states that are banning punitive damages claims in almost every instance, that's what we need to be looking at because there's a time and a place for making a plaintiff whole. There is a very, very limited time and a place for punitive damages, especially when we're looking at what is punitive damages intended for, right?
Yeah.
It's intended to change the system, is what I hear.
If you were a doctor that came in and did your surgery drunk, punitive damages probably should apply. Right?
100%.
That's an egregious situation.
But when you're looking at, okay, the goal here is I want to change your systems. I want to have this hospital system pay a bunch of money because they had bad policies in place and I want them to change it and taking a bunch of money will make them change it. Okay, but when we're looking at it for doctors and we're saying that that's the case, how are punitive damages doing anything for doctors but causing fear? And when does fear prevent a doctor from making a mistake?
Never.
If you're scared, if you're stressed, if you're overwhelmed, you're going to make more mistakes.
Exactly.
Not less.
Exactly. If policymakers, let's say I could get in everybody's ear about this, policymakers, hospital leaders, public elsewhere in the country, if they could hear this, what would you want them to know about how a malpractice climate like the one New Mexico has had, how this reckless use of punitive damages when it's left unchecked, how it affects access to care? How would you advise them to protect their workforce? What should they do?
If we want to have more doctors, if we want to have better access to care, more specialists in our state, we have to look at the policies that are driving medical malpractice claims. We need to place better caps. Those caps need to come down of punitive damages. And we need to ensure that when a punitive damages claim is alleged and it goes before a jury, it's actually warranted to be there. It should not be going to a jury just because New Mexico just favors summary judgment and wants the jury to hear all of the facts and decide what should happen. The jury should be hearing only the facts of claims that should survive. The scales are still shifted. They're still tilted too far, and we need to keep working to bring them back. New Mexico needs to continue to work on passing compacts for other providers and healthcare professionals. There's a bill that was pending that died, unfortunately, and didn't make it through the session, that was looking at barring any collection of judgments against a doctor's personal assets, whether they're part of the Medical Malpractice Act or not, which is an outstanding position where the doctors can then sit there and defend good medicine. Because we can't ask doctors to sit there and take that risk and say, defend good medicine, but if things don't tip your way with 12 strangers, you might lose everything. We need to keep working to ensure that our doctors feel protected, that they feel wanted in their communities, because otherwise we're going to keep seeing increases in defensive medicine. We're going to see doctors leaving. And when doctors leave, patient access deteriorates because now we have to drive hours, hundreds of miles to find a primary care physician or specialist. That just causes more delay. Or you have practices where now we have significantly more air transport of patients out of state, which puts further strain on our neighbors and their hospital systems. We need to bring them back, and we need to show them that we want them here, and we are going to work as a group to increase access to care through better laws and policies, through incentivizing doctors to stay here, and through appropriately compensating patients when something goes wrong to ensure that they're taken care of.
I've even heard from locums placements companies where they're trying to get locums doctors into New Mexico. I've heard doctors now just be like, oh no, I've heard about New Mexico. You send me anywhere else, but I'm not going to New Mexico. Like, I won't risk that. And that can happen anywhere. And so it's not to paint you as a cautionary tale, but it is something that we all need to open our eyes to. But I really did want to shine a light on the issues with access to care, and particularly this use of punitive damages. As I said, it's absolute psychological warfare. It ought to be illegal, and if it's not illegal, then it should be exceedingly rare. And the fact that they're just knee-jerk applying this with 90% of cases in the state, to me, is like, that's what's egregious.
It is. And it's all an attempt to bypass the caps that are in place. You know, you put one fence in the way and they're going to find a way around it.
Well, especially if they're in the legislature, right?
Right. And that's what's happened. And those that are in the legislature have said things like, we're not going to comply with the way that this new law is written. We think that it violates New Mexico Constitution. We think that there's going to be issues with this. And it's going to be a fight to keep what we've got and to continue to make it better. But it's definitely a fight worth having. And I think doctors need to know that if you're in this situation where you're being sued, not only do you need to work with your lawyer to defend your case, but I think you really need to take care of yourself. Doctors, I think all of us benefit from therapy, but especially if you're being sued, I think it would be helpful to ensure that you have an outlet somewhere where you can talk about those anxieties and those fears.
Yeah.
Because even if we make all of these changes, it's still a scary situation to go through. It still weighs on you and how you're going to practice going forward.
I heard you when you said that you were worried about that one client. And we've talked on this podcast before about how litigation in general, forget the punitive damages, but litigation in general is a driver of suicide. That is something that we know. That's something that we have data on. And so the fact that this additional layer of extraordinary stress is being placed on doctors who are under so much other stress altogether. I mean, there are limits to what any human can handle. And I think it is time to fight back. So thank you for coming and talking to us about this. Thank you for fighting the good fight. Hopefully there are ways that we can support you over there. I appreciate you.
Absolutely. I think the more of us that can come together and have these conversations about what's working in certain states and what's not, and what we can do to push the message across the board, it's only going to be more help. We need to work together more often. The other side already is.
Thank you again, Attorney Jessica Marshall, for your expertise and your time. Thank you also to Dr. S. for sharing your story. And finally, thank you for listening. Take the information you've learned in this podcast, not to make you afraid, but to make you empowered, to find out what should our next steps be, to talk to your colleagues about it, to find out what are the rules around punitive damages in my state. Could they be more protective of your workforce? What can we do to protect access to care in our state? And then get going. All right, everyone. I'll see you next month.